So number one question, define evidence and explain its scope. So evidence is a means of sanction by these rules and ascertaining in a judicial proceeding the truth respecting on a matter of fact. Scope, the rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. Number two, what are the three kinds of evidence? So briefly explain each. So under section one, object has evidence. Objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. So section two, documentary evidence. So documents as evidence consist of writing, reading, photographs, or any materials containing letters, words, sound, numbers, figures, symbols, or their equivalents or other modes of writing expression offered as a proof of their content. So, Section 21, testimonial evidence. So, all person who can perceive or perceiving can make known their perception to others may be witnesses. Number three question, distinguish corroborative evidence from cumulative evidence. So, cumulative evidence is additional evidence of the same kind bearing on the same point. Example is testimonial of several eyewitnesses to the same incident. While the corroborative evidence is additional evidence of a different kind of character but tending to prove the same point, it is evidence which confirm or supports. So number four, what is prima facie evidence? So prima facie evidence is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. Number five, what is dying declaration? What about statement uttered as a part of the res gesti? So the declaration of dying person made under the consciousness of an impending death may be received in any case wherein his heard death is the subject of inquiry, as evidence of the cause and surrounding circumstances of such death. While the statement made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as part of the res gesti. Number six, what is the order of examination of individual witnesses? Briefly define each. The order in which an individual witness may be examined as follows: A. Direct examinations by the proponent. B. Cross examination by the proponent. C. Redirect examination by proponent. And D. Cross examination by proponent. Number seven, briefly explain what is a judicial affidavit. So, judicial affidavit shall contain a sworn attestations at the end, executed by the lawyer who conducted or supervised the examination of the witness. Number eight, an offer of compromise in criminal cases is an implied admission of guilt. What are the two exceptions? In criminal cases, except those involving quasi-offense criminal negligence or those allowed by law to be compromised. Number nine, in order evidence to be admissible, it must be relevant and competent. So when evidence relevant and when is evidence competent? So when evidence is relevant, it must have such relations to the fact in issues as to induce belief in its existence or non-existence. While evidence is competent, means sufficiency of evidentiary support from the totality of the record which proves an issue of fact. Competent evidence include evidence which possesses probability value commonly accepted by the reasonable mind. Number 10. What is the order of examination of individual witnesses? Briefly define each. The order in which an individual witness may be examined is as follows: A. Direct examination by proponent. B. Cross examination by the proponent. C. Redirect examination by proponent. And D. Recross examination by proponent. 11. What is the leading question? When is it allowed? A question which suggests to the witness the answer which the examining party desires is a leading question. Is not allowed except A. On cross-examination, B. In preliminary matters, C. When there is a difficulty in getting direct and intelligible answer from a witness who is ignorant, a child of tender years, is of feeble mind or deaf mute, D. Of unwilling or hostile witness, E. Of a witness who is adverse party or an officer or director or managing agents of a public or private corporation, or a partnership or association which is the adverse party. Number 12. What is misleading question? A misleading question is one which assumes as true a fact not yet testified to by the witness, or contrary to that which he was previously stated. Number 13. When is the circumstantial evidence sufficient to sustain a conviction? Circumstantial evidence is sufficient for conviction if there is more than one circumstances, the fact from which the inferences are derived are proven, and the combination of all circumstances is such as to produce a conviction beyond reasonable doubt. Inferences cannot be based on their inferences. Number 14. Distinguish burden of proof from burden of evidence. So, burden of proof is the duty of the party to present evidence on the facts in issue necessary to establish his her claim or defense by the amount of evidence required by law. Burden of proof never shifts. While the burden of evidence is the duty of the party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. Burden of evidence may shift from one party to the other in the course of the proceedings, depending on the exigencies of the case. Number 15. What is the standard of proof necessary in civil cases, criminal cases, and administrative cases? In civil cases, the standard of proof is the preponderance of the evidence. This standard requires the injury to return the judgment in favor to the plaintiff if the plaintiff is able to show that the particular fact or event was more likely than not to have occurred. While criminal cases, the burden of proof is on the prosecution, and the standard required of them is that they prove the case against the defendant beyond reasonable doubt. And administrative cases, the quantum of the proof in administrative proceeding necessary for a finding of guilt is substantial evidence or such relevant evidence as a reasonable mind may accept as adequate to support a conclusion. Number 16. Define what are public documents. Public documents are A. The written official acts or records of the sovereign authority, official bodies, and tribunals and public officer, whether of the Philippines or of a foreign country. B. The documents acknowledged before a notary public except last wills and testaments. C. Documents that are considered public documents under the treaties and conventions which are in force between the Philippines and the countries of sources. And D. Public records kept in the Philippines or private documents required by law to be entered therein. All others writings are private. Number 17. How do you prove and present in court private documents? Before any private documents offered as authentic is received in evidence, its due the execution and authenticity must be proved by any of the following means. A. By anyone who saw the documents executed or written. B. By evidence of the genuineness of the signature or handwriting of the marker. And C. By other evidence showing its due execution and authenticity. Any of other private documents need only be identified as that which it is claimed to be. Number 18. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the four exceptions? A. When the original has been lost or destroyed or cannot be produced in court without the bad faith on the part of the inferor. B. When the original is in the custody or under the control of the party against whom the evidence is offered, and the later fails to produce it after the reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in the court without a great loss of time, and the facts sought to be established from them is only the general result of the whole. And D. When the original is a public record in the custody of the public officer or is recorded in a public office. Number 19. Who can become a witness? All person who can perceive and perceiving can make their no perception to others may be a witness. And number 20. When is an extrajudicial confession sufficient to sustain a conviction? An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti.